the strings.
Okay. Ready?
Good morning, Your Honors. It may please the court. I'm Thomas Burns, and I represent Antonio Ruiz and Maria Hernandez. I'd like to reserve 5 minutes, please. In Maldonado, the Florida Supreme Court held landowners owe duties to those injured on their property, and those duties arise in two main ways. The first is common law negligence. Landowners owe duties for their active or passive negligence whenever something other than the premises condition causes injury. That's footnote 2 of Maldonado.
Stop you there. Do we have any of that here?
Did
the landowners in this case act in negligent in any way?
Well, that's my point. It's active or passive negligence, and it's the injury is caused by something other than the conditions of the premises. So what the
So I assume we're talking about passive in this case.
yes.
Okay.
And so what happened?
I don't need to interrupt you, but we might as well get right.
I'd rather you ask me the questions and I answer them. So what the landlord did here is it either allowed or turned a blind eye to repairs happening on the lot. And these are obviously commercial trucks. They're extremely large. They're very heavy. Like when they're empty, they weigh like 40,000 pounds. When they're loaded, they weigh, I think, 80,000 pounds. And
so they turned a blind eye, but the written leases that existed didn't they have a provision that said you can't do this type of work?
Well, there were some written leases and there were some oral leases. And Wendy, who is the one woman whose truck Antonio was repairing, didn't have a written lease. She had an oral lease. So I think that question goes to control and whether the lease would absolve the landowner of responsibility. And here we don't have that established because
they're drilling too hard down onto this, just to sort of establish the point. The position is they have responsibility for passive negligence, and their passive negligence was they had a policy you can't repair your trucks on the lot, and they did not enforce their own policy.
They claim to have a policy to not repair the trucks. That's, I think, disputed.
You're not even sure about
That's
that.
disputed.
Okay.
But even if they did have it, they didn't enforce it, or they turned, like I said, a blind eye to it. And you might then think, well, what else could they have done? And the record answers this question. It says, well, you need to have like a key lock procedure in place where you don't have somebody with the key while somebody's working on it.
That's from the expert.
That's from the expert, and that gets in because the affidavit was timely.
I don't dispute that.
Okay.
It's time, and I don't know that Mr. Tinker disputes that either. The question is, it appears to be rife with legal conclusions because Mr. Zombauer opines on zoning issues, land use issues, ingress, egress, duties upon individuals who operate a commercial vehicle repair business. Well, this wasn't, I think you would even agree, is not a commercial vehicle repair business. So it seems to me that an affidavit that's rife with legal conclusions seems to evade the province of the court. The court has authority to disregard it.
I agree with you on the general principle that witnesses can't opine about the law. I don't think that's what his affidavit was doing here. I think he was opining about how the industry understands the regulations that govern them.
Mr. Garcia running this industry of commercial vehicle repair, I just don't think.
Well, he was allowing it to take place. So if he's allowing that kind of business to take place on his property and he's charging money while these people are parking it and allowing it to happen.
He's only charging rent, he's not charging the mechanics.
Yeah, and the mechanics were there to service the tenants who were his tenants, so he wasn't in the business of doing it. I mean, these tenants leased spots either orally or in writing, and they were fixing their equipment that was sitting in these spots. I mean, I got to tell you, as I read this case, I was thinking to myself, if I had a truck and I leased that spot, I'm darn sure want my mechanic come out and fix it there.
Right.
And
that's why it's so ideal for these truckers to have this. It's like a cheap lease, and they can have their mechanic come, and nobody's really asking questions about it. And maybe if you go to a fancier place, they say, oh, you have to use our mechanic, or oh, you have to comply with all these regulations. And by the way, that costs us money to do that, and you have to pay more rent. So here,
and I guess the question becomes, there's twofold in here. First of all, this is a tragic accident. I mean, the way the facts are, he's working underneath this huge truck, fixes it. I guess that Wendy is in the cab itself. He tries to get out. I mean, she thought he was out and she basically runs over him. It's just, I mean, it's horrible.
Wendy wasn't in, it was somebody else,
Somebody
but
else.
like you read in the transcript, she ends her description of it like, my God, it's awful.
Exactly. So there's no question that this is a horrific, horrific accident. But the question for us, and becomes a legal question, is there a duty, number one? Is there, and this is where it goes back to law school, okay, who has the duty? Is there a breach of duty? Is there, and then you go through that, which then goes back to the questions that were mentioned. This is somebody who owned this acre of land, decides to lease that because he gets rent and allows these semi trucks to come in and park, okay? And some of these semi trucks, when they're parking there, some people come in, change a tire, that happens, change of oil, that happens. But in this case, this was some major repairs being done. And you're taking the position, and this goes back to the affidavit. The affidavit said this was negligence, but you raised something in your briefs, and I want to, I'm putting this as a background to get to this. You took the position that the trial court excluded the affidavit for timeliness. But in reading through the transcript, the trial judge did not do that. The trial judge basically focused more. I don't see a breach of duty. So the issue about excluding the affidavit, because if you look through that, you brought it to her attention, whoever the trial lawyer was, but judge, this was timely, and she kind of acknowledged it, and she went through the crux in making the ruling that she did not see that, so.
Okay,
this is where I
so
want to focus.
the affidavit doesn't establish the duty, the affidavit establishes the breach. When we're talking about the duty, that depends on the analysis that I started with, which is whether it's common law negligence.
You got number two to still.
Yeah,
tell us.
common law negligence and premises liability. So let's talk about the common law negligence. That depends on whether the landowner created a dangerous situation or allowed the dangerous situation to exist, and whether the scope of the risk. So that the duty is triggered by the creation of the dangerous situation. The dangerous situation is truck repairs, heavy duty truck repairs are happening with very heavy trucks. That's obviously a dangerous situation because we know how serious the injury was. And it's certainly foreseeable that if a truck breaks loose and rolls over a human being, that's bad.
But I understand foreseeability may be a fact legal issue, but here, the reason that he excluded mechanics was environmental.
Yeah.
So he had nothing in his mind about dangerousness or injury. So in his mind, no, mechanics are not coming on because I just don't want to spoil this land just in case I want to resell it. So you don't have any indication that he knew this was dangerous in any way whatsoever. And despite Mr. Dudley's testimony, well, mechanics are here all the time. None of the mechanics were doing what your client was doing, unfortunately.
I don't think that's an accurate description of the record, and the inferences that we're entitled to is the non-movements in the summary judgment motion. There's a number of witnesses that say lots of repairs were happening. They describe those repairs as heavy duty. If you look at the testimony of Charles, Wendy, Rainier, and Tito, and especially the testimony of Charles, he says everybody was coming and doing heavy duty repairs.
Well, but to Judge Sleet's point, this is 5 acres of property, lots of trucks all over the place. You know, Roberto Garcia seemed to be, from my read also, he was worried about oil, discarded batteries. I didn't get anywhere that he was worried about people getting hurt or any of that. He was worried about contaminating his valuable piece of property. So, and that probably leads a lot to why he wasn't aggressive in enforcing it, because he was worried about taking care of himself and his property. He didn't have on his mind, I got to take care of other people so they don't get hurt. I think he worked from the assumption these are commercial truckers, these are experienced mechanics. These guys know more what they're doing than I know. I'm a tile setter. I don't know what they're doing. That's the way I read it.
Okay, so I have 2 answers, and I actually didn't answer the beginning of your question, Judge Sleet, which had to do with his subjective intentions or subjective knowledge, and it's also to do with your question, Judge Morris. When we're looking at duty, it's not really the subjective knowledge of the tortfeasor. We're just looking in general, objectively. Would a reasonable person in that position have known, or could they have reasonably foreseen that this kind of injury would happen? And our answer to that question is yes, for the reasons that I stated. It's like they're heavy trucks, people can get injured. The point you're making, I think, Judge Morris, is one that goes to comparative negligence. And that could be a great jury argument. Like, look, this is a mechanic, he has experience, I'm just the tile setter. Jury, he's more responsible than I am. But that's not really a summary judgment argument, and it's certainly not an argument that goes to duty, because that's purely a legal question. At most, that could go toward breach, which is a factual question. So I think with that understanding of the common law negligence law, it's kind of easy to see where, in my view, where the trial court went sideways on this. That the trial court took a myopic view of the case. It said this is a premises liability case. It's not a common law negligence case. And so it overlooked all of these questions about the dangerous situation and the creation of the risk. Instead, it just jumped straight into, well, what was Antonio's position on the property? Was he an invitee? Was he a licensee? Was he a trespasser? And that's where the court, I think, went wrong, because it really should have looked at this as a common law negligence question. Now, we've gotten a little bit into the facts, naturally, because this is a summary judgment issue. And I think this is where the summary judgment standard is so important. The answer brief, I think, describes the record in a way that's incorrect at the summary judgment stage, because it's describing the record in the light most favorable to the movements. We get the record read in the light most favorable to us, and we get the inferences, the reasonable inferences. So they characterize the repairs that are happening, or the whatever's happening there is just routine daily safety inspections. And I think you alluded to that earlier, Judge Sleet. Like, well, isn't that really what was happening? Well, the answer is maybe, but that's a question for a jury. We have testimony from Charles, Wendy, Rainier, and Tito that indicates that very heavy duty mechanic repairs were happening all the time. And in fact, they were happening so frequently that Tito asked Roberto to hire a supervisor to make this stop. And Roberto says, no, I don't want to spend the money. If you look at Charles's testimony, he says, quote, he saw, well, some of this quote, some of this is me. I saw a lot of other guys that had mechanics coming and going who performed, quote, heavy duty mechanic work, unquote, which required going underneath a tractor trailer all the time. Wendy said she had mechanics coming all the time to repair her truck, despite, nobody told her not to do that. And Reiner said he saw people changing tires and fixing brakes. These are all things that require lifting. I don't know if you've ever done work on cars or trucks, but like you have to lift the thing or somehow get underneath it. And that's where the significant danger is. Like if you're changing the oil, you just stand over it and you change the oil. But if you have to change the brakes or the tires, you got to lift that thing. And if you're lifting a 30,000, 40,000, 80,000 piece of machinery, that's dangerous. And it's foreseeable that it's dangerous because, you know, gravity is a thing. I explained how they didn't have the safety precautions in place. And these should be fairly obvious whether there's an affidavit or not in the case. They didn't have somebody to hold the key. They didn't have somebody prohibiting people from entering the cab, and they didn't have a supervisor to make sure that these rules were followed.
That was more or less a best practices suggestion from an expert, right?
No, that was what the industry standard is. So not just best practices. This isn't like the gold standard of how we do things. This is like, this is what we do. And if we don't do it, people get hurt, and we know people get hurt.
But if he were running a commercial, commercial repair service, that's what he'd have to do. That's not what he was doing. He was only leasing stuff out. I mean, so those practices should be relative to the lessees, not to him, because he's not running a business of fixing stuff. He's running a business of just leasing spaces.
If those were the facts, you might have a better case for that he didn't have that duty. Like if you had written leases that said you can't have mechanics come on, if you had signs everywhere saying this is forbidden, if you had employees going around saying, hey, you're doing something you're not supposed to, stop it.
No,
but that didn't happen.
My point is he wasn't in that business. His lessees were availing themselves of those services. So why is it incumbent upon him to put in these safeguards on a business he's not in?
So that has to do with the landowner part of the equation, and it's because he has control of the property. And because he has control of the property, he has the ability to allow people to do things or not allow people to do
Well,
things.
is he making all these people get COVID vaccines?
The record
Well, it's
doesn't
got
say, and
control.
this might have been before. This is a little bit of an older case, so this might have been before the.
You understand my point, though?
Uh,
Yeah, I mean, how far does this go? He's not in any of these businesses.
Right, and the question really then is the two things. Did the landowner or the person in control of the property create a dangerous situation through their action or inaction? Yes or no? And the answer we say is yes, because there are heavy trucks and he's turning a blind eye to the repairs happening. So that situation is dangerous.
You're
And-
into your rebuttal time, and I just want to let
Give me
you know that. It's your time.
10
Do whatever
seconds.
you
So,
want to.
and then the next question is, well, so the duty's triggered. What's the scope of that duty? The scope is extensive because the risk is extensive. And we know that because the injury is so horrible and it's obvious that this kind of injury could easily happen if a truck breaks loose. Thank you.
May it please the court. Good morning. Mark Tinker on behalf of Roberto and Jesus Garcia.
Mr. Tinker, isn't this purely simple duty? What is duty? Isn't this boils down to, and again, it's a horrific case, but the question is, was there duty in this case? Is
No.
that a legal thing?
It is a legal thing. Yes, that's what it was.
That's what it boils down to.
Yeah.
And it makes a difference. You can't have it both ways. You can't argue common law and then argue premises liability. We're talking about two different things. If it's premises liability, clearly these facts will not warrant that. They don't like the premises liability because it doesn't bode well. So the question is duty.
And I think I don't agree with the concept that there's this negligence and also premises liability and that they're separate. What they're arguing is the active versus passive concept, saying, well, we can say that you negligently failed to do something on your property. That's still premises liability. I mean, if their concept was true, there would be no such thing as premises liability. If you owned, a sidewalk and had a crack in it, they could say you negligently failed to fix that crack and that's why it tripped. That's a premises liability claim. Or you did fix it, but when you fixed it, you put something on there that's too slippery. So it's still premises liability. So they're saying you actively fixed it wrong. You actively decided not to fix it. You actively turned a blind eye to it. It's all premises liability. That's what this case is.
So let's say that this homeless guy that Tito hired, sitting at the gate, tells the plaintiff who wanted to leave because Wendy's not there, say, well, wait, she's coming, she's on the way. Wendy shows up, invites him in, let's just say he's an invitee.
Mhm.
What is your client's duty as to him?
At that point, he was an invitee because when he first got there, he was inspecting the truck and he looked at it to see what was wrong with it. And I think there was problems with the translation, but he decided they needed a rod or something. So they had to go leave and buy it and come back. When he came back, and this is the key to this whole case to me, when he came back, they're saying you had this duty to prevent mechanic work from being performed on the property. He came back for the express purpose of performing mechanic work. So this, to me, falls into, this court's Byers versus Radiant Group case, which was the case where, if you're like me, you're bad with names. I know more facts than names. These are the people that went to the convenience store for legitimate purpose, bought some stuff, went out in the parking lot, ended up in a fight in the parking lot. This court's discussion, Judge Wallace wrote a majority opinion, Judge Altenburn wrote a large concurrence. And there's a discussion about, well, it depends on what they were there for. If they were there and, were there for a legitimate purpose and ended up getting in a fight and had to defend themselves, then they're probably still invitees because they were there legitimately doing something.
What
if-
if Mr. Garcia showed up with the rod initially? And
Well,
invited in?
that's where it gets to this, because the next part of what the court talked about in Byers is they said, if you went there with a specific intent to fight, how can you claim that we have a duty to prevent a fight from happening? If they had left and decided, you know what, those people in the parking lot really made us mad, we're going to go back, get the bat out of the trunk, we're going to go back and we're going to get them. Now you're going back and doing the thing that you're claiming I need to prevent or protect you from. Their entire lawsuit is saying you should have prevented people from doing heavy mechanic work here. He went there to do heavy mechanic work. So he's saying that we needed to protect him from the very thing that he brought to the property. There's no duty on a landowner, on behalf of a landowner, to do that. And to me, I mean, that's the entire case. Is that I think that makes him a trespasser at that
So
point.
the duty depends upon the plaintiff's motive,
Well, if
as opposed to just letting somebody that doesn't belong on the property into the property to do what potentially could be dangerous for them.
I think it can go both ways, but I think in this case, I mean, what they're saying is your obligation was to make sure nobody did any heavy mechanic work here. And he went there for the express purpose of doing the heavy mechanic work and then says that we had a duty to stop him from doing what he's doing. I don't believe that a landowner has a duty to prevent somebody from that or to provide protection from that.
So would your analysis be different if a innocent bystander was hurt by the truck that rolled?
I think if this truck did roll and hit another truck, I think that might be a different claim. There might be a whole different discussion there.
So then split that hair with me. Why? What's the difference between the rolling truck hitting an innocent bystander and the rolling truck crushing the mechanic who was under?
It's the same difference of a negligent security claim. If I walk into a property with a gun and I shoot an innocent person, then they would have a claim. If I walk in there and I shoot myself in the leg, do I have a claim against the business that I just walked into? I went there to do the thing that I'm saying you need to protect me from, or you need to protect people from. You can't be both the assailant and the victim at the same time. And that's basically what he's doing. He's saying you need to make sure there's no mechanic work going on here. I'm going to go there and do mechanic work and then sue you for not stopping me from doing the mechanic work I came here to do. That's just, there's no duty to do that.
I want you, Mr. Tinker, to address the affidavit issue, because I know we spoke with Mr. Burns about that. And I know his brief, you said that Judge Peacock, first of all, excluded it. And reading through the transcript, did she really exclude it, or she basically chose not to consider it? Or did she look at it and she just went on and came to the ruling that there's no duty in this case?
From what I recall, she did say, I'm not going to consider that. I don't know in the context that she said it. She didn't, it wasn't a timing ruling. I don't believe she looked at it. And I think she reached kind of what Judge Sleet was getting at is, first of all, the affidavit was full of legal conclusions. Most of them had nothing to do with a parking lot. He was talking about, here's what you need to do if you were running a repair facility. And he was talking about zoning obligations and you need to hire people and have key locks and all these things. Somebody running a parking lot doesn't need key locks. They don't need, to have all of these zoning requirements and lifting equipment and all those things. So he went on to talking about what he thinks should happen if you're running a repair facility. So it was factually inapplicable. It was full of legal conclusions. And if we're talking about duty, an expert doesn't opine on duty. That's a question for the court. So most of his affidavit was inapplicable. A lot of it had to do with, what would be the standard of care for a breach if there was a duty. But I mean, from what we were just discussing, as far as if you have somebody going onto a property to do something that they're saying you should protect them from, there's no duty to do that. And an expert affidavit can't address that opinion. That's something for the court to decide.
Well, I'm concerned about arguing duty, but also blending that in with your argument about whatever the plaintiff decided to do once he got there. Obviously, if he decided to just go inspect the truck, this would not have happened. But he goes in there, inspects it, figures out what's wrong, and decides to fix it, right or wrong. Well, that had occurred before. We don't know to what extent, but according to Mr. Dudley, you got facts in the record. Mechanics are there all the time. Everybody had mechanics. So I'm trying to reconcile what you're saying, because it seems to me what you're saying is the decisions that he made exempted your client. Well, that seems like comparative negligence.
No, I believe it's still a duty issue, and I'll use the same analogy. Do I have a duty if I'm, I own a business, I have a duty to provide security, to make sure it's a safe place against crime. Do I have a duty to stop you from walking onto my business and shooting yourself in the leg? So it's your own motivation. It's your, what brought you to my property, but I don't have a duty to do that because you're telling me to provide security. You're the one that came in and did the thing that you're asking me to secure against.
You would agree Tito could be arguably his agent. right?
Tito?
Your client's agent.
Yes.
Okay, so Tito hires, I don't even know his name, he's a homeless guy.
I'm not sure that anybody knew his name. I think there's a first name, I think, in the record
I'm
somewhere.
sure he was even hired. He doesn't have to be there.
I think
He
it's
was-
reference to the homeless.
I think it was
guy, I
a
think.
trade. You
Sounds
can
like
live
he was A
here.
little bit lower than Barney Fife, but
Yeah.
he just welcomed everybody in. Hey, he just wanted to make friends with everybody. So the duty still applies. Once the plaintiff walks up and says, I'm here for Wendy,
Mhm.
just go ahead.
And like I said, I think that's fine. He was a business invitee of Wendy's. He's welcome to be there. He's welcome to inspect the truck. But if the entire lawsuit is to provide, and I'll just continue with my same analogy. I walk into your business, you have a grocery store. I walk in there and I do legitimate business. I buy a couple sandwiches. And then as I'm walking out, I shoot myself in the leg and say, you should have provided better security. You can't do the thing that you're saying you need to be protected against. You're changing yourself from a business invitee to, at that point, you're a trespasser because you're doing something that has no legitimate purpose that I should be protecting you from.
So your position basically as a landowner has no duty to safeguard a lessee's business invitee from his business dealings with that lessee, right?
Correct.
Now,
Yes.
let me put words in your mouth because
I think you're reading from my
Okay.
brief, actually.
Yeah, I think that's exactly what I am. Got a quote from your brief. So that being the case, your opponent's key cases are Hicks, Maldonado, and Florida East Coast Railway.
Mhm.
And they appear to be pretty darn persuasive. Why aren't they?
They aren't because, and actually, if you look at the Nicholson versus Stony Brook case that I cited, it goes through all three of those and distinguishes them. And what it says is none of those were premises liability cases. In all three of them, there were active injuries that would have existed regardless of where they occurred. Hicks, the car which caused the injury, could have caused the same injuries if it was located someplace else. It wasn't a premises liability case. It was you hit me with a car case. Florida East Coast Railway was the same thing, except it was a train. Maldonado was the hydraulic lifting machine, would have been, and it doesn't matter if it was on their property or if it was on a neighboring property, this liability still exists.
They
And
sue the landowner in Maldonado, which is a horrible accident. But
I
that's a
believe so.
child.
That's
Somebody lets a child's employee ride on a goat.
right. Right. And it would not have mattered if they did that in the orchard where they were, or if they were on a separate piece of property. They're saying the liability existed because they allowed the child to be in there and allowed the employee to bring their child to work and all of those different things. It wasn't tied to the fact that it was on the land. It was tied to the activity. And I think one of the best cases that describes this is Florida East Coast versus Gansiorski, I'll pronounce it, because it had both in it. It had the active and passive negligence, and the court went through and looked at it. This was a man who was walking along. He tripped over some railroad spikes that were laying on the railroad company's property, and then for some reason went and sat down on the railroad tracks, and a train came along and hit him. And they said, well, that's both. When he tripped over the railroad spikes, that's passive negligence because it's just a condition on the property. The only reason that would happen is the only reason liability exists is because that's on my property. When he was sitting on the railroad tracks, the problem was that it was the same railroad's train and employee that was driving the train negligently failed to stop, hit him. That liability would have existed whether it was on their property or on, he'd walked farther down the tracks and was on, government land or something. The liability would have existed anyway, so it wasn't tied to the property. If you look at this case, if the same exact incident happened on the side of I-4, Mr. Ruiz had fixed Wendy's truck on the side of I-4 a couple of weeks earlier. If it had happened exactly the same way, but there, it'd have no possible reason to sue the Garcias. The only reason they had to sue the Garcias is because it happened to happen on their land. It makes this a premises liability case. And that's completely different from Hicks, Florida East Coast, and Maldonado, because the liability would have existed no matter where it was. It doesn't matter whose land it was on.
That comes circling to the very first question.
Okay.
Is there a duty in this case?
No, there is not. And, I don't want to say, like I said, I think it comes down to, what this court laid out in Byers. It has to do with, are you a trespasser? Or, there are duties, but it depends on different duties owed to different classes. So there are duties, yes. But in this case, his duty is owed to a trespasser because he went there to do the thing that he's saying we should have not allowed to happen,
Well, there's probably no duty to warn for sure, right?
for sure.
So
And
signs wouldn't
I've-
matter because there is no duty to warn if the visitor's knowledge of the danger is equal or greater than the landowner's, right?
Correct.
But what about these safety protocols that the opposing counsel has described, the key in the lockbox and all of that? Is there not a duty? I mean, he knew this work was going on, had to, he either knew or should have known. Repairs were being made on this 5 acres laden with commercial trucks. He saw oil filters, dispensed oil filters laying on the ground, discarded batteries. You know, he had actual knowledge. Was there some kind of duty on his part saying, geez, I don't want them to do this stuff, but I've leased these spaces to these people, so I've kind of lost some control, not all of control. I'm still the owner, but should I put these procedures in effect? I mean, is there a duty for him to do that?
no, like you said originally when Mr. Burns was up here, because he's running a parking lot. So what you're almost asking me is, does he have a duty to transform his business to match what he sees people doing there? I own a parking lot. I see people changing batteries. Well, I guess I better go, well, almost like the affidavit said, start pulling zoning permits and change this into a repair facility and then put in the safeguards. No, there's no duty to change your land to meet what people are doing on it. He ran a parking lot. There's no lockbox requirements for a parking lot. Unless there are any other questions.
You got 5 more minutes.
Well, drove all this way, I know, but thank you for your time. I appreciate
Thank
it.
you.
Can I take the 5 minutes?
You on the other hand have 4.
Mr. Burns, I wish it was over.
My colleague is making precisely the arguments that were rejected in Maldonado. Maldonado, it was a grove, it was the landowner, and the grove was not running a daycare. There they were asking people to come pick fruit, and there were children that the grove knew was there, and they were in proximity to, again, heavy machinery, and there was an awful accident. They still had a duty, and that duty didn't arise from premises liability, it arose from common law negligence. And the reason was it wasn't caused by a condition of the premises, it was caused by the action or inaction of the landowner in allowing the dangerous situation to exist. My colleague makes a point, he's like, well, when would we ever have premises liability, and uses an example of a sidewalk. A sidewalk is not a dangerous situation. That's when premises liability takes place, because the landowner's action or inaction didn't create a dangerous situation. It's just whether there was a duty to warn or a duty to maintain. And that's why Maldonado is such an important case and why it controls.
A parked semi is not really a dangerous situation.
I'm sorry?
A parked semi is not inherently dangerous.
When it's parked, but when it's being worked on and it's elevated, and
Who told them to elevate it?
by the person who is leasing the space that told the mechanic to do that. When correct. And then the question is that we're all running around constantly. So what is the duty? There's 2 categories of duties here. One is the potential duty to prohibit this activity in the first place. And then there's the second category of duties, which is the lockbox, the supervisor, the don't have somebody in the cab. And we're arguing both, but the main thing I want to focus you on is those 3 duties about the lockbox, the cab, and the supervisor. That's really why this injury took place. If he'd taken those additional precautions, if he'd paid somebody to be a supervisor, and if he told everybody that they needed to follow these rules, in all likelihood, this horrific injury would not have happened. My colleague cites 2 cases, Byers, which is from this court, and Nicholson, which I believe is from the 4th district. Byers is that extreme circumstances case. And here there are no extreme circumstances where there's like a gunfight or something, or a horrible brawl that breaks out. Here, somebody who's leasing a space says, hey, mechanic, Antonio, come check out my truck. And Antonio says, there's a problem with your truck. I know how to fix it. And she says, okay, fix it. That he has at all times the permission of the lessee to be on the property. At no time does he become a trespasser, and he's not engaged in any criminal activity. So there are no extreme circumstances like in Byers. The Nicholson case, which comes out of the 4th district, it's either distinguishable or it's just inconsistent with Maldonado, and for that reason not not the least bit persuasive. It describes Maldonado as an active negligence case. There was no action on the part of the landowner in Maldonado. It was just a dangerous situation that the landowner didn't remedy. And Maldonado is very clear about it doesn't matter whether it's action or inaction on the part of the landowner, because they go out and say that in footnote 2. And like I said, that's not dictum because it was a passive negligence case. So the remedy that we're asking for you here is to reverse the order, remand this case for further proceedings. And in addition, we've talked a lot about the affidavit. I think we should instruct the judge to consider that affidavit as to breach, because it's got some factual explanation there, but the court was correct that it doesn't go to duty because duty is a legal issue. So sum up, reverse, remand, further proceedings.
Thank you.
Thank you.
Thank you.
You all did a great job on a tough case, and this is a classic case of an example where we don't get to be human beings. Because we all feel terribly bad for what happened to your client. But obviously, we cannot take any of that into consideration. We got to follow it straight on the law, but it's my heart goes out to him because he really suffered a lot. Thank you both. You're
Thank you,
both
Mr.
great lawyers.
Thank you, Mr.